The defense lawyer had no arms and no legs. Find out why I went to the trial judge to prevent this lawyer from talking about his own disabilities. Come join me as I share with you this remarkable story. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. So now, here's a case involving a gentleman who was on a subway car that came to a grinding halt, came to a short stop, and he goes flying and suffers significant spinal injuries. Now, we go in for trial in Brooklyn, and the defense attorney that represents the transit authority is a remarkable individual. Here's a gentleman who has no arms and no legs from the time of birth. This gentleman has managed to become a very successful and very good trial attorney. Now, he has prostheses for his arms and his legs. And one of the things that I needed to do was to make sure that this defense attorney, during the course of jury selection, did not talk to the jury about how significant his disabilities were and compare them to the injuries that my client was claiming in this case. You want to know why? Could you imagine him turning to the jury? What a successful argument this would be. Ladies and gentlemen, look at this guy. He can't do all these things. Look at me. I'm able to do all these types of things on a daily basis, and look at what I've accomplished in my life and in my career. There's absolutely no reason you should award any compensation to this guy because his injuries are not that significant. Well, of course, when you compare it to somebody who doesn't have any arms and legs, it is wildly insignificant. But the reality is, the defense attorney's own disabilities should play no part whatsoever in this particular type of trial. So now we go in front of the judge, and I make my argument. It's known as a motion in limine. And that's where I present my argument to the judge before trial. And now the judge hears argument on that. And the judge knew this defense attorney. And he says, what do you have to say about that? The defense attorney did a remarkable job explaining to the judge why he should be allowed to talk to the jury about his own disabilities and compare them to my client's. The judge ultimately decided in my favor and directed this defense attorney that he could not talk about his own disabilities, even though it was obvious for everybody to see. But the fact is that I had to go into the trial judge and ask him specifically to prevent this lawyer from prejudicing the jury and not talk about his own disabilities and comparing it to my client's. So why do I share this great information with you? I share it with you to give you an insight and an understanding into one particular case I handled where I now had to go to the trial judge to prevent something significant from happening by the defense attorney. You know, I realize you've got questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.